Today, I will deal with constitutional law. It is a body of rules, doctrines, practices governing operation of political communities. What is political communities? It means the uh, governments or the leaders that people rely on in nations. So there's the operationalization shons of political affairs, governmental functionaries, services such as on the part of economy, on the part of uh, health, social welfares, education, and priorities for poor, and so on. The policies involved. In modern times, most important political community has been the states, the country. Modern constitutional law is offspring of nationalism. This is what we rely on. Whereas of idea that state must protect certain fundamental or obvious rights of individual. As number of states has multiplied, so have constitutions, and with them body of constitutional law, meaning that there are no subparts of constitution or constitutions. Though sometimes such law originates from sources outside the state, or what we call, if we espouse international law or laws for that matter, the customary international law as part of our laws in our land. Protection of individual rights, meanwhile, has become concern of supranational institutions, specifically since mid-20th century, as the bedrock of the creation of constitutions. Constitutions and constitutional law. What is its nature? In broadest sense, constitution is body of rules or the collection of rules governing affairs or socialism or functions or lives of people in organized groups or for our matter, our nation. Parliament, church, congregation, social club, or trade union, such as business partners, even the local and stratified uh, commerce, etc., may operate under terms of formal written document labeled Constitution. So, Constitution is their sort of their promises combined, compiled as one book for that matter. Not all rules of organization or organizations are in Constitution. Many other rules, example, bylaws, and customs also exist. These are the old or traditional principles that people follow. By definition, policies spelled out in Constitution are considered to be basic in the sense that until they are modified according to appropriate procedure, all other rules must conform to them. Meaning that until special cases step in, the basic laws are to be applied. Thus, presiding officer or the leader of organization may be obliged to declare proposal out of order if it is contrary to provision in Constitution. He may intervene, or she, to have smooth sailings transactions among them. Implicit or unclear in concept of Constitution is idea of higher law that takes precedence over all corollaries. Every political, as we said earlier, political or group of leaders of communities, and thus every state or country has a constitution that they follow in order to reach their desired outcomes or products or social services, at least insofar as it operates its important institutions to institute progress forward in accordance with their fundamental body of rules. By this conception of term, only conceivable alternative to constitution is condition of anarchy, or what we call in colloquial the going out of limb. Is to be accepted if it is sensible. Nevertheless, form constitution may take varies considerably. They are variable. Constitutions may be written or oral. Just a mere compact or conditions, codified or not, and complex or ordinary, and they may provide for vastly different patterns of governance, such as what we witness. There's federalism, there's democracy, there's monarchy, there's communism, there's patriarchy, there's on the basis of how rueful you are, on the part of being assertive or razy or fighter or education, and so on. In constitutional monarchy, as mentioned a while back, for example, sovereigns' powers are circumscribed by constitution, meaning that it is scrutinized carefully, thoroughly. Like we witness in a democracy, there is the so-called checks and balances, whereas in absolute monarchy, the sovereign has unqualified powers. It is not tested or explained. Political communities' constitution enunciates principles that are determinants instituting to which task of governing is entrusted, along with respective powers. In absolute monarchies, which is we do not appreciate, in a disparate sort of governing body, as in ancient kingdoms of East Asia, Roman Empire, and France between 16th and 18th centuries, all sovereign powers were concentrated in one person, being king or emperor, who exercised or discharged them directly or through subordinate agencies as intermediaries, acting according to instructions of the two mentioned. In ancient republics such as Athens and Rome, constitution provided, as do constitutions of most modern states, for distribution of powers among distinct or different institutions. But whether it concentrates or disperses, meaning that it's the opposite. These powers, constitution always contains at least rules that define structure and operation of government running community. So there's agreements involved. Constitution may do more than define authorities or powers endowed or entrusted or granted with powers to discharge. It may also delimit those powers so as to secure against them certain fundamental or obvious rights of persons or factions. Idea there should be limits on powers state may exercise is deeply rooted in Western political philosophy or psychology well before the advent of Christianity. Greek philosophers thought in order to be just, positive law actually enforced in community, ought to reflect principles of superior ideal law, which was known as natural law. The natural flow of societal operations day in, day out. Decades after decades, similar conceptions were propagated in Rome by Cicero. (106-43 BC) and by Stoics. Later, church fathers and theologians of scholasticism held positive law is binding only if it does not conflict with precepts of divine law, meaning that it does not go against or fight the superior laws. These abstract considerations or synthesized considerations were perceived and received to certain extent in natural rules of positive legal systems applied in certain governmental functionaries. In Europe during Middle Ages, for example, authority of political rulers did not extend to religious matters, such as what we follow in our Philippine Constitution. And I quote, churches and governmental walks are inviolable, which were strictly reserved to jurisdiction of church. Their powers also were limited by rights granted to at least some classes of subjects only, meaning that there are limitations. There are those that simply they cannot apply on. Disputes, or in for that matter, over extent of such rights were not infrequent and sometimes were settled through solemn legal pacts or agreement between contenders. Compromises and bargains ought to be kept on both sides. Both are benefiting, such as Magna Carta 1215. Even, quote, absolute, unquote, monarchs of Europe did not always exercise genuinely absolute power. That's why we always say, wherever in the world, we are never absolute. Even with ordinarily merely living, carrying out our natural rights as citizenry. King of France in 17th or 18th century, for example, was unable by himself to alter natural laws of kingdom or disestablish Roman Catholic Church. I think that the sacramental phrase here is that it ought to function as collegiate company. Against this background of existing legal limitations on powers of governments, decisive turn in antiquity of Western constitutional legal scriptures occurred when political or governmental psychologists developed a theory or a draft idea of natural law based on, quote, inalienable rights, unquote, meaning that rights which are ordinarily invalidated or un, un, inactioned or ignored by institutors of individuals, their individual liberties. English philosophers like John Locke in the year 1632 1704 was early champion or supporter, or what we call in pedagogy, advocate of this doctrine. Oh, ano yan? Others followed Locke, and in 18th century view they articulated became banner of enlightenment. This is what we call a term of art or a special concept. These thinkers asserted every human being or every person like us is endowed with certain liberties, freedoms, including freedoms to worship according to one's conscience. Could also be interpreted your upbringing, your faith that it's immutable, and you're free to worship whatsoever God you grew up worshiping. Otherwise, if you transfer to other deity of other uh, troops, you'll end up tingling your conscience to express one's opinions in public, to acquire and possess property, and to be protected against punishment or sanctions on the basis of retroactive laws, or what we call the automatically applicable no debate laws, and unfair criminal proceedings. Governments cannot, quote, take away, unquote, because they are not created by governments or political philosophies, by philosophers at the helm in the first place. They, moving along, assumed governments should be organized in a way affording effective uh, immunity for every liberty. Thus, it was thought as minimal prerequisites, uh, governmental functionaries must be divided into legislative, executive, and judicial, like ours in our Republic of the Philippines. This God-forsaken territory. Executive action ought to be complied with rules given by legislature. Who are the legislatures? Senate and House. And local legislatures for rules and procedures, counselors, board members, and so on. And remedies administered by independent judiciary must be, who are the judiciaries? Judges, appellate, uh, Supreme Court justices, okay, headed by the Supreme Chief Justice, okay, and executive, the president, mayors, and so on. Doctrine of natural rights was potent factor in reshaping of constitutions of Western countries in 17th, 18th, and 19th centuries. Early stage of this process was the introducing of English Bill of Rights in the year 1689, product of England's glorious revolution that they called. All these principles concerning division of governmental functionaries and appropriate relations were complemented into constitutional law of England and other Western territories. England also immediately changed some of its laws so as to give more ample legal force or energy to newly pronounced individual liberties of its citizenry. In United States, doctrine of natural rights was even more successful. Doctrines. These are still legally binding in nature. Scriptures perceiving natural rights. Once American colonies became independent states in the year 1776, they faced problem of giving themselves fresh governmental organization, which is of course expected because of course the precedence is that turmoil. They seized or captured opportunity to spell out legal documents to study, which could be amended only through special procedure. Main principles for distributing governmental functions among distinct state agencies and for protecting rights of individual as doctrine of natural rights required federal constitution drafted in the year 1787 at Constitutional Convention in Philadelphia to replace failing Articles of Confederation and its subsequent Bill of Rights ratified in 1791. Did the same at national level by formally conferring through these devices higher status on rules defining organization of political and limited its legislative and executive uh, positions. United States constitutionalism displayed essential nature of constitutional law. Fact, it is basic, quote unquote, with respect to all other laws of country's legal system. This feature made it possible to establish institutional controls over conformity of legislation with group of rules considered within system to be of supreme importance, the system for common good. American idea that being basic rules guiding operations of government should be stated in orderly, comprehensive, understandable document quickly became popular. From end of 18th century, scores of countries in Europe and elsewhere followed example of US. Today, nearly all states have constitutional documents describing uh, corollary organs of state, ways they should operate, and usually rights they must respect, and even sometimes goals they ought to reach. Not every constitution, however, has been inspired by individualistic ideals permeating modern Western constitutional law. Constitutions of former Soviet Union, like we read back in junior high, and other communist countries subordinated individual freedoms to goal of achieving classless society in order to ensure what is inscribed in common belief, societal belief that we are all bad equal and should be treated as that. Notwithstanding great differences between modern constitutions, however, they are similar at least in one aspect. They are meant to express core of constitutional law governing respective countries for progress. Babalos. I don't know. It might be that my next topic would be on the economy, but I will have to make sure, deciding as yet. Many thanks.